names and terms. I mean, Johnson & Johnson backed LTL in the subsidiary that it created to the tune of a $61 million funding agreement that J&J, when it did the Texas two-step and split it into two companies, one with the assets and one with the liabilities, you entered into a $61 million funding agreement. Did you disclose the terms of that?
Congresswoman.
LTL was in bankruptcy.
Correct.
LTL's funding was coming from J&J. Did you disclose the terms of the $61 million funding agreement?
Congresswoman, unfortunately, I don't have an answer to that question for you right now. I'm happy to take it back.
Haven't J&J lawyers insisted that the sworn deposition testimony about that financing agreement be deemed confidential? Haven't they argued that to Judge Kaplan in New Jersey in the bankruptcy court, that LTL management, your subsidiaries' funding and financing for the purpose of defeating this litigation must be kept confidential, even as you sit here today and try to tell us that the plaintiffs should have to disclose all of the details of their financing?
Congresswoman, respectfully, I think that we're talking past each other. I think those are two different things.
Why?
Funding agreement related to the structure of bankruptcy, as I understand it. We're talking about...
But the bankruptcy, excuse me, Ms. Wien, the bankruptcy only exists, and LTL management as a company only exists as a response to the talc litigation. It didn't exist until you tried to defend against the talc lawsuits. J&J was the third-party funder of the LTL company that went into bankruptcy to deal with the talc claims, and you argue, your company argued in court that those should be confidential. And yet, you want the other side, the plaintiff side, to have to disclose all of their funding. I think that's hypocritical. I think it is the same.